in the Supreme Court of Georgia decided August the 13th, 2024. All right. S24Y0800 in the matter of Jonathan R. Melnick, per curiam. All right. The disciplinary matter is currently before the court on the report and recommendation of the State Disciplinary Review Board, which recommends that Jonathan R. Melnick, State Bar, his number is 501254, be given a public reprimand and undergo a law practice management assessment based on his violations of Rules 1.3. And the rule of 1.3 says a lawyer shall act with reasonable diligence and promptness in representing a client. Reasonable diligence, as used in this rule, means that a lawyer shall not, without just cause to the detriment of the client, in effect, willfully abandon or willfully disregard a legal matter entrusted to the lawyer. So basically, talk to your client. All right. And Rule 1.2 or 1.4. Rule 1.4 provides a lawyer promptly informs the client of any decision or circumstance with respect to which the client's informed consent, as defined in Rule 1.0, is required by these rules. Reasonably consult with the client about the means by which the client's objectives are to be accomplished. Now, remember what I said. A lawyer, no matter how bad or how much it will impact your client, you got to let your client know the information that you got if you're a lawyer. So so this is based on the violations of those rules of the Georgia Rules of Professional Conduct. I mean, really? Found in Bar Rule 4-102. I wish they do this to the prosecution. I wish they did this to the prosecution. He's a defense attorney. Okay, Melnick is a defense attorney. I wish they would do this to the prosecution. Haven't the prosecution violated more than these two rules? I'm just saying. The review board adopted the findings of fact and conclusions of law of the special master, Lorraine Dixon Moore, who recommended a 90-day to 6-month suspension for the reasons discussed below. We agree with the special master that a 6-month suspension is warranted. Here's the factual background. Okay, here we go. We're about to get into this. The following facts were either found by the special master or were established without dispute at the hearing. Melnick has been a member of the state bar since 1994. He received 2 investigative panel reprimands in 2003 and an investigative panel reprimand in 2006. What? Oh, okay. Okay. D Pill. Thank you. Okay. So he left early yesterday because he had this is the case. This is the court case about the child, about the child custody, I think. Okay, here we go. Thank you for that information. So he received 2 reprimands in 2003 and another one in 2006. All 3 matters involve violation of Rule 1.4 and 2 involve Rule 1.3 violations. Let's read this right here. All right. It says, keep the client reasonably informed about the status of the matter, promptly comply with reasonable requests for information, and consult with the client about any relevant limitation on the lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the Georgia rules of professional conduct or other law. A lawyer should explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding their representation. Absolutely. I want my lawyer to tell me what's going on so that way I can make an informed decision about what I want to do with with the person representing me and what I want to do with myself. So that makes perfect sense. In May 2017, Melnick began representing a client in a matter filed in Rockdale County by the father of the client's child. Melnick began representing. I'm sorry, I just got a notification about something else here. Okay, sorry. Melnick began representing the client in a matter filed in Rockdale County by the father of the client's child. The father was paying child support via an income deduction order and was seeking a reduction in child support, as well as to legitimate legitimate the child and obtain visitation. During that time, Melnick was a solo practitioner with no full-time staff and no case management software. Oh my God. He handled between 50 and 80 cases. What? Oh, he handled between 50 and 80 cases at any given time and was in court 17 out of 20 days each month. He used a software program to manage his calendar and communicated with his clients primarily after typical business hours. In March, and again, there are some footnotes here that we're gonna read up on here, but I think it's the same thing that we read before. In March 2018, Melnick, his client, the father, and the father's attorney participated in a voluntary mediation where the parties were able to reach an agreement on a reduction in child support. However, the parties still needed to agree on visitation and prepare a parenting plan. The parties agreed that the father's reduced child support payment would become effective April the 1st, 2018. And that if a new income deduction order was not in place by April 1st, 2018, April Fool's Day, Melnick's client would reimburse the father each month for the difference between the child support amount paid pursuant to the income deduction order and the reduced amount agreed upon at the mediation. Okay. After the mediation, the parties notified the court that they had reached a settlement and would be submitting a final order. So the court removed the case from the trial calendar. The father's attorney emailed Melnick a draft consent agreement about a month after the mediation and asked that Melnick's client begin reimbursing her client for the child support overpayment. Oh, don't get me started with this child support, dog. Okay, here we go. Oh my goodness. Almost a month later, Melnick responded, "Please call me." The two attorneys exchanged a few emails during May and June about a visitation schedule and the amount of the reimbursement. In early August, the father's attorney sent Melnick a revised consent agreement with a parenting plan included. A week later, Melnick responded that the parenting plan was fine, but that he was not going to agree to a refund of the child support since April. The father can take that up with child support. The following day, a Friday, Melnick emailed the father's attorney that he believed that it would not be proper for his client to send the reimbursement to the father's attorney. The following Monday, the father's attorney filed a motion to enforce the settlement agreement. What? This guy here, dog. The motion also sought an award of attorney fees for having to file the motion. Jesus. Melnick did not send his client a copy of. Melnick did not send his client a copy of the motion or otherwise inform his client about it. God. He also did not file a response to the motion because he felt it was unnecessary. Melnick planned to handle the attorney fees issue at the hearing and believed he could prevail pretty easily on it. Yeah. Huh? What? Your client is supposed to reimburse child support and overpayment of child support. There was a motion for you to enforce the settlement agreement. Y'all settled on this. You never told your client, you never gave your client a copy of this. What? He also did not file a motion to response again because he felt it was unnecessary. Melnick planned to handle the attorney fees issue at the hearing and believed he could prevail pretty easily on it. The trial court scheduled a hearing on the motion for January 8th, 2019. This has been going on since 2017, y'all. Melnick did not tell his client about this hearing. Jesus Christ. He's not telling his client nothing. Melnick did not tell his client about this hearing because he had a conflict for that date. He emailed a conflict letter to the judge's administrative assistant 5 days before the hearing was scheduled in an attempt to comply with the Uniform Superior Court Rule 17.1. And this is a footnote here. While the judge's assistant acknowledged receipt of the conflict letter, Melnick did not follow up with the court to determine if the hearing would be rescheduled. He didn't follow up with the court. It sounds like Melnick is not an efficient lawyer. What you guys think? What you all think about this? Melnick he doesn't sound like he's efficient, man. Sounds like he got scatterbrained a little bit, you know? And I mean, I understand there are some people who try to multitask and they can't, but he was a solo practitioner and he had like 50 to 80 cases. Yes, thank you. Melnick needs an assistant. You know, I don't understand. You have 50 to 80 cases. You in court 17 to 20 days out the month, bro. 17 out of the 20 days in the month that you're supposed to be in court. You in court over 90% of the time. He says, no, he's not a good attorney. Yeah, it doesn't seem like you had 2 violations in 2003. You had another violation in 2006, all related to and they were all similar to each other. You know, and it's not to say that he doesn't know exactly what he's doing, but maybe he's just not efficient. That's why I don't want to say that he doesn't know he doesn't know law. Obviously he kind of does, but his efficiency, man, is not good. Well, this is the Supreme Court doing this. Time said, Tabiz, why this case come up now about Melnick? I believe Attorney Love and Fani Willis is behind this because of Woody. This happened in 2017. They was holding on to this. It's possible, but this is not coming from that. This is coming from the Supreme Court. This is coming from the special master of the appellate courts. This is not even coming from the DA's office, I don't think. So it's already specified early in this motion, in this order from the Supreme Court. It's not even coming from, it's coming from a lady named Lorraine Dixon Moore or something like that we read. So it's not even coming from the DA's office. And this has been an ongoing issue too. This is started in 2017 all the way up until 20, and we're in 2019s now. So I don't know if this is DA related, man. Honestly, I mean, I gotta be objective here. We're still reading this. I'm only on page 6. So give me some time. Hey, yo, time, give me some time, okay? Because I don't know, man. So somebody dropped a dime, but again, this is coming from the Supreme Court. So I'm not too sure. I know we're in 2024. That's the point. Look, when it comes to the appellate courts, the appellate court can take a long time to review a case. When you have a case that lasts for 2-3 years, we're talking about a child custody case. y'all. Hold on for a second, y'all. We talk about a child custody case that lasted from 2017, and we're just getting into 2019. We don't even know how far along this case goes. This is just page 6. This is the factual background of the case. When an appellate court looks at a case, it depending on how long the case is, it could take the appellate court a long time to look at a case that's 2, 3, 4 years. That's exactly what they're gonna do to the Young Thug case. This Young Thug case been going on since what, 2021, 22? We in 2024 right now, and they're gonna do the exact same thing they just did with this case. They're gonna do it with the trial, with the RICO trial. They're gonna review this boy, and it's gonna take a long time to go through all the transcripts and all the things that happen. So I'm not gonna just go down this conspiracy hole just yet. Although I'm the king of conspiracy theories, but I'm also the king of conspiracy possibilities as well. All right. Trust me, just because this is 2024, that means nothing to me. This case lasted for more than 2 years. This case lasted more than 2 years. So give me some time. See, I will. Plus, these lawyers and court people are concerned. You know what I'm saying? Just give me some time. You know what I mean? Just give me some time, baby. Let's do this. All right, let's get into this real quick, right? Because this is good. This is interesting. This is interesting. Okay, while the judge's assistant acknowledged receipt of the conflict letter, Melnick did not follow up with the court to determine if the hearing would be rescheduled. The court conducted the hearing on January 8th. Another footnote. And this is January 8th, we're still in 2019. See that? We're still in 2019. After Melnick was finished with the other matters for which he was scheduled to be in court on that day, he called the court and was told the hearings were done. He did not ask about the outcome of the hearing and did not contact his client to tell her he had not attended it. Jeez, man. I want to rock with Melnick, but dog, this is nasty work. On January 15th, 2019, the court issued a final order enforcing the settlement and ordering Melnick's client to reimburse within 30 days $2,820 to the father for child support overpayment, as well as pay $809.93 in attorney fees related to the motion to enforce. After the trial court issued the January 15th order, Melnick did not notify his client about the order, did not tell her she had to pay $3,629.93. Oh, that damn child support. Oh, boy, I'm telling you, I'm trying not to get hot like Woody. Like I got steam coming off my bald head like Max Sharp, like Mad Max. Come on, man. Your client owes this man $3,629.93 that they settled on. Let's look at the footnotes real quick. Uniform Superior Court Rule 17.1b requires that a lawyer who has a scheduling conflict provide written notice of the conflict to opposing counsel and to the clerk of each court and to the judge before whom each action is set for hearing. And that such notice is expected to be given, such that it will be received at least 7 days prior to the date of conflict. Whether it was proper for the trial court to hold a hearing in Melnick's absence in light of his conflict notice is not before us in the disciplinary matter. Okay. This is she had to do this within 30 days, and he did not give her a copy of the order. The client became aware The client became aware of the January 15th order when, after the amount she was receiving in child support decreased, she went to the courthouse and obtained a copy of the order. That was also when she became aware of the January 8th hearing and motion to enforce. Melnick never filed a motion to withdraw from the case, nor did he terminate his representation. The client retained new counsel who contacted Melnick and raised the possibility of the client filing a malpractice action against him. See, this is why we got to take some time. We got to take our time. You feel me? Okay. This is why we got to take our time, man. Yo. The client retained a new counsel and they contacted Melnick and raised the possibility of client filing a malpractice action against him. Melnick discussed settlement with the client's new counsel, and after the client filed a grievance with the state bar, Melnick paid the client $3,500 and obtained a release. Melnick paid the client $3,500 and obtained a release. Yo, man. Let's look at the footnote. Because this is a footnote right here in this paragraph. I think that's the only footnote on this page. Hold on, let me see. The footnote says the testimony established that Melnick paid his client $3,500, but the record is not clear as to whether that amount represented a refund of the fees the client paid Melnick or was generally based on the amount the client was ordered to pay by the trial court's order on the motion to enforce. So we don't even know what this $3,500 was even for. Are you reimbursing the client because of your time? Because you're talking about representing somebody for 2 years on the same case. I know it costs more than $3,500 to retain you. Stop playing with me. Stop playing with me. Put stop playing with me in the chat. Put stop playing with me in the chat. You know what this $3,500 was for. You was trying to give her the money so she could pay for the actual reimbursement that she owed and those court fees. By the way, you short $169.93, my boy. Because I know to retain you costs more than this. You are a solo practitioner. Stop playing with me. We're going to have some merch real soon, y'all. Trust me, I got you. We're going to have some What Up, Though shirts. We're going to have some Stop Playing With Me shirts. We're going to have some Nasty Work shirts. We're going to have some stuff, man. Okay? We're going to get some mugs. I'm telling you, stop playing with me. Dude, I know my dude on the other end, like, yo, where's my money at? Where's my 36.96.93? I know the dude on the other end, like, sir, or attorney, I have not received payment of my reimbursement. I have not received nothing. Oh, nasty work. Stop playing with me. Look at you. Stop it. Stop playing with me. Stop playing with me. You're just trying to throw me $3,500 so I can cover what I owe this man over here and the reimbursement of the attorney fees from that motion. That's all you trying to cover, bruh. Unbelievable. Look, Tom said Tay Bill's attorney Love Hilton and Fani Willis still do dirty work. Yes, sir. Stop playing with me, Tay Bill 100. Exactly. They doing dirty work down there right now. Right now, they doing dirty work, man. Stop playing with me. After the evidentiary hearing and consideration of the parties' briefs, the special master concluded that Melnick willfully violated rules 1.3 and 1.4 and that his conduct harmed his client. The maximum sanction for a violation of rule 1.3 is disbarment, and the maximum sanction for rule 1.4 is a public reprimand. Woo-hoo-hoo. It's amazing that Okay, but still, I got to say this though. I got to be real. It's amazing how they could do this with defense attorneys and solo practitioners, but they don't do it to the prosecution. They never do this to the prosecutor, and the prosecutors do misconduct all the time. All the time. This is ridiculous. But I mean, this doesn't negate the fact that he was on some bull. Okay, it doesn't negate the fact, but still, I'm just saying. In addressing the appropriate level of discipline, the special master considered the facts and circumstances of the violations. This court's precedent in similar disciplinary cases, mitigating and aggravating factors, and the ABA standards for imposing lawyer sanctions. And it says here, see in the matter of Morris 266 GA 652 653. It says the special master concluded that 4 aggravating circumstances applied: prior disciplinary offenses. So it's a pattern of misconduct, a pattern. How many patterns have we seen with the DA's office? Huh? How many patterns have we seen with the DA's office? Huh? Yeah, we seen pattern of misconduct a lot in the thug trial for sure. Since you want to talk about Melnick, talk about that too, though. Okay, I'm sorry, y'all. I'm getting a little ahead of myself. Substantial experience in the practice of law and refusal to acknowledge the wrongful nature of his conduct. And by the way, to do this in a fashion where you don't even consider the time required to talk to your client about this is kind of crazy. It is kind of crazy. The special master also determined that three mitigating, and this footnote right here from this right here, it says wrongful nature of his conduct. Says the special master noted that Melnick disappointingly attempted to place the burden on his client. He attempted to place the burden on his client for failing to reach out to him over her displeasure with the case. You gonna blame me? You're gonna put the burden on me? How dare you? How dare you, bruh? Oh, I would be so hot, bruh. I would be so hot, dog. The special master also determined that 3 mitigating factors applied. First, she considered the existence of personal and emotional problems that Melnick said he suffered. She considered the existence of personal and emotional problems that Melnick said he suffered. Although she gave this factor only some weight, noting that some of the circumstances Melnick relied upon as mitigating did not occur during the time frame in which he was representing the client, and that Melnick, who had been given an opportunity to submit documents after the hearing, did not submit any documents supporting his testimony about having participated in counseling. Second, Melnick made a timely, good faith effort to make restitution or rectify consequences, as he eventually paid his client $3,500. Finally, this is what the special master considered. All right, this is the consideration before they just start laying down the law. They have to consider some things. Okay. Finally, the special master recognized that Melnick had not received the disciplinary sanction since 2006. Right. The special master did not address Melnick's. Oh, there's another footnote. Where was it at up? Oh, okay, I see what it says. So it says here, Melnick testified that he had marital difficulties for many years, had cared for both his parents through long-term serious illnesses, had ongoing health issues of his own, and had participated in counseling. At the conclusion of the evidentiary hearing, the special master invited Melnick to submit to her with a copy to the state bar any documents that would support this aspect of his testimony. Okay, so he had marital issues. He had his parents had some illnesses. He had health issues of his own. He was in counseling. So the master is like, okay, I need some documentation for you to support that, so I could consider what I need to do. Okay. The special master did not address Melnick's argument that she considered as mitigating factors that he lacked a selfish or dishonest motive, that he was cooperative with the disciplinary authorities, that there was a delay in the proceedings that was not caused by him, given that the formal complaint was filed 2 years after the grievance was filed and was based on events that occurred over 5 years ago. Okay. And that he was remorseful. All right. Addressing the sanction that was warranted, the special master determined that a public reprimand was not appropriate. A reprimand is appropriate for violations of rules that occur based on negligence rather than knowing behavior. So the special master determined that a public reprimand was not appropriate, and that Melnick's prior disciplinary history subjected him to enhanced discipline. Says bar rule 4-103 says a finding of a third or subsequent disciplinary infraction under these rules shall in and of itself constitute discretionary grounds for suspension or disbarment. All right. Instead, she recommended that Melnick be suspended for a period of between 90 days and 6 months, consistent with prior cases, such as in the matter of Sakas 301, GA 49, blah, 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 blah. Accepting special master's report on petition for voluntary discipline and imposing a 6-month suspension for a lawyer who violated Rule 13 and who previously received 2 formal letters of admonition and public reprimand. Accepting special master's report on petition for voluntary discipline and imposing a 4-month suspension for a lawyer who violated rules 1.3, 1.4, and 1.16, and who previously received 3 confidential letters of admonition for similar conduct. Okay. Also, accepting special master's report on petition for voluntary discipline and imposing a 6-month suspension for a lawyer who violated rules 1.3, 1.4, 3.2, and 8.4. And number 4, and who previously received 2 confidential letters of admonition, including in 1994. Accepting special master's report on petition for voluntary discipline and imposing a 6-month suspension for a lawyer who violated rules 1.3 and 1.4 and who had prior discipline in the form of a 90-day suspension. It says agreeing with review panel's report and imposing a 6-month suspension for attorney who violated rules 1.3, 1.4, and 1.16, who suffered from a physically disabling illness during the representation, and who previously received a formal letter of admonition and a confidential reprimand. Accepting special master's report and recommendation and imposing a 120-day suspension for a lawyer who violated 1.3 and 3.2 and who had prior discipline in the form of an indefinite suspension. Now, here's the review board's report. Oh man, this is crazy. We're on page 12. All right. I'm gonna try to skate through this. Melnick filed a motion asking the review board to review the special master's report. He contended that he did not violate Rule 13 and that in any event, a public reprimand was more appropriate. The review board concluded that Melnick violated 1.3 and 1.4, adopting the special master's factual findings and conclusions of law in all respects except with regard to the consideration of Melnick's prior disciplinary history as an aggravating factor. The review board stated that it discussed at length the prior disciplinary history and believed that the more than 15-year period since any prior disciplinary history should not only mitigate, but also should outweigh the extent that this history is considered an aggravating factor. Okay, that's what you're saying. So the fact that he hasn't had a reprimand or whatever in 15 years, or more, he wants it to count for something, which I can get. I can get with that. I can understand that. It is also disagreed with the recommended discipline and recommended that Melnick receive a public reprimand, which concluded was consistent with prior cases, such as in the matter of Pagano. Accepted petition for voluntary discipline and imposing a review panel reprimand for attorney who violated rules 1.3, 1.4, had two prior disciplinary actions, and there was no indication that attorney took any steps to ensure the client was made whole. And that's just talking about the review board, what they expect here to exact and specific punishment, because they have not been able to find any past recommendation of a range of punishment by a special master in a contested disciplinary case, and because the special master sat in the best position to recommend a specific sanction. Okay, gotcha. Okay, that's self-explanatory. It says here, accepting petition for voluntary discipline and imposing a review panel reprimand where attorney who was the subject of two formal complaints after having been disciplined 3 times within the last 9 preceding years, made effort to make aggrieved party whole and lack of selfish motive. Okay, that's the $3,500. I'm gonna come down, I'm gonna skate down here a little bit here. I'm gonna pass through that. It says the parties' arguments. In its exceptions to the review board's report, the state bar asserts that the review board failed to adequately consider the differences in this case from the cases cited by Melnick, including that all 3 cases involve respondents who filed petitions for voluntary discipline in which they admitted to the wrongful nature of their conduct and were cooperative in the disciplinary proceedings. So it seems like in this particular motion, Melnick is not trying to escape from his issue. He's letting you know, like, I just don't want to be indefinitely suspended, which I can understand. Hold on one second. Shout out to my man, My Take TV. I appreciate he gave a $3 super sticker. Thank you so much, man. I appreciate it, man. Thank you so much for the love. Everybody put My Take in the chat. Put My Take in the chat. Show My Take some love. Thank you so much, man. I appreciate it. Thank you so much. It says here that the state bar notes that Melnick never filed a petition for voluntary discipline and failed to comply with discovery and the scheduling order filed in the case, which resulted in the state bar having to file a motion to compel, and that he has continued to place the blame on his client and minimize the harm of his actions. Thus, the state bar contends that this case is more in line with in the matter of him, in which we held that a short suspension would likely be a sufficient sanction to make clear to the respondent and other members of the bar the importance of acting with diligence to ensure that the circumstances that led to misconduct are addressed before additional similar misconduct can occur. Excuse me. So the believe here, this is the report of the parties' arguments here. And Melnick gave some case law stating that there have been other cases where something similar like this happened, and that they didn't get a disbarment or anything like that. It wasn't indefinite. So I don't want to have an indefinite disbarment. I would rather just take the public reprimand, and I just don't want to be disbarred. So that's basically what he was saying in his response to what was going on. So I totally understand that. Let's go ahead and skim down just a little bit. Says here, in his response to the state bar's exceptions, Melnick argues, as he did before the special master and review board, that he did not violate 1.3. In his view, There was no need to file a response to the motion to enforce because it did not seek any relief that was not already incorporated into the parties' settlement agreement, other than the portion related to attorney fees. Yeah, but at the same time, man, you said you didn't inform your client that that the reimbursement had to be done, though, and like the actual hearing happened. Um, Moreover, while he acknowledges that the better course of action would have been to file a motion for reconsideration as to the issue of attorney fees after the motion to enforce was granted, he states that he does not believe that the failure to do so constitutes willful abandonment. I don't know, man. It's kind of shaky. In addition, Melnick argued that his prior discipline was remote in time, that by paying his client, he had demonstrated his remorse, and that the payment should be considered as mitigating because he made it before the formal complaint was filed. Hey, bro, you try to cover your tracks, dog. I understand, but no, dog. I'm still hot. I'm still hot. And that the court should consider it mitigation, his lack of a selfish motive, his cooperation with the process and the delay in these proceedings. He also asserts that the state bar contends that his failure to file a petition for voluntary discipline should lead to a harsher sanction, and argues that he is not in any way trying to understate his remorse or acceptance of responsibility, but simply believes that he did not violate 1.3. Okay. All right. He contends that he contends that attorneys have received much less serious discipline than what has been proposed here under similar circumstances where payment has been provided to the aggrieved party and there was a lack of selfish motive. All right, let's go down here a little bit. Let's go down here. Analysis and conclusion. Let's get to it. We generally defer to the special master's findings of fact so long as they are supported by the record. When we review de novo the conclusions of law reached below and what rules were violated and what level of discipline is appropriate. Can somebody find out what de novo means in lawyer terms? But we reviewed de novo the conclusions. I don't know if that means like without prejudice or anything like that. I'm not sure. Likewise, while we defer to factual findings unless clearly erroneous regarding conduct that may constitute a mitigating or aggravating factor, whether the facts constitute an aggravating or mitigating factor is a matter we consider de novo. I'm about to find out what that means. Hey Siri, you know what I'm saying? What does de novo mean in lawyer terms?
Get a free consultation with a highly rated lawyer. Get a free consultation. De novo definition. De novo. Latin for anew. Meaning to do something over again as if for the first time.
Okay. So meaning to do something over again as if it's the first time. All right. Start from the beginning. Thank you. Appreciate it. Yep. So it's like anew. It's like doing it all over again like it's the first time, like it's fresh. All right. Okay. So the consideration is de novo. Okay, got you. We learn something every day, people. We learn something every day. It's almost 1:00, so I want to hurry up and get to the actual part where they do the order. The issue of mitigating. Let's get to here. All right, so it says, with regard to aggravating factors, we agree that Melnick's substantial experience in the practice of law and his lack of remorse are properly considered an aggravation. Melnick's attempts to cast blame on his client and his characterization of any harm to her as very minimal reflect a lack of remorse. Ooh. Noting that we may consider actions during the disciplinary process as aggravating factors. We also agree that Melnick's prior disciplinary history, which involved conduct similar to the conduct at issue here, is an aggravating factor, but we do not give the existence of those offenses great weight, given that the sanctions were imposed 12 to 15 years before the misconduct in this case, and that there is no evidence of any disciplinary actions against Melnick for over a decade. So that kind of helped him. All right. Nevertheless, the existence of 3 prior disciplinary sanctions authorizes the exercise of our discretion to impose a suspension or disbarment under Bar Rule 4-103. Having carefully reviewed the record and these parties' contentions, we determine that a suspension is appropriate given. We determined that a suspension is appropriate given that Melnick's misconduct was willful rather than negligent and harmed his client, and the fact that he has received 3 prior disciplinary sanctions for similar conduct. We further determined that the mitigating factors do not outweigh the aggravating factors. Ooh, the Supreme Court is serious. Thus, based on the particular facts of this case and this court's prior precedent in similar cases, we conclude that a 6-month suspension is the appropriate sanction for Melnick's violations of Rules 1.3 and 1.4. Accordingly, it is hereby ordered that Jonathan Melnick is suspended from the practice of law in Georgia for 6 months. The suspension based on this opinion will take effect as of the date this opinion is issued and will expire by its own terms 6 months later. After this passage of time, there is no need for Melnick to take any action either through the state bar or through this court to effectuate his return to the practice of law. However, Melnick is reminded of his duties pursuant to Bar Rule 4-219. 6-month suspension. All the justices concur.